Hello, everyone, and welcome back once again to another very exciting episode of Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, once again, friends, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam, and today we are going to dive into a very important and a very timely topic, and that is about H-1B Modernization Rule. So, in today's session, we are going to understand that how will the 2025 H-1B Modernization Rule is going to transform the US employment for foreign workers. So I'm sure, most of the people are getting very much concerned about like how the new policies will be, how the new rules will be, and how will be the process all about. And I think to understand that everything in detail, I have a best expert advice for you, friends. So please help me in joining the attorney who has been joining us for the second time in Immigration and Jobs Talk Show. So let me welcome attorney Karen Lee Pollak, who is the managing attorney of Pollak PLLC, a top immigration law firm based in Dallas, Texas, and Florida. And the firm provides a full range of immigration services to business, families, and individuals as well. So, Karen, first of all, very much, we are really happy to have you again with us, and we are honored that you have joined us. So, thank you so much for joining. And how are you doing right now?
Hi, Sam. Thank you so much for having me. It's an honor and a privilege to appear on your show again, and I'm excited to delve into this new topic of the 2025 H-1B Modernization Rule.
Absolutely. I think today the topic is going to be very much important, for us to know about. So I'm sure that we are going to gain lots of information, lots of, knowledge about today's topic. So once again, welcome everyone, and it will be great if you could also join us from any of the platform, that is YouTube, LinkedIn, Facebook, or Twitter, as well, as we are live on these many platforms. So post your questions and let us know what questions you are having for today's topic. Karen is here with us for an hour. So we will definitely take those questions and provide the best solution and the best answer to it. So, Karen, without any further ado, I would like to know from you that what our viewers can expect from today's episode.
Well, I think we're going to delve into the 2025 H-1B Modernization Rule, what it is, what changes they can foresee in filing H-1B petitions, what different rules there'll be, and different standards in adjudicating things. And then we have some good news for H-1B self-sponsors by entrepreneurs who want to file their own H-1B through their own company.
All right. So I hope today's session is going to be very informative, and I'm super excited for it because our last session, I remember, it was very much informative, and also, the explanation that you provided was in a very simple term, and our audience also loved that. So I'm sure today's session is also going to be the same. And with that, Karen, here's my first question: that what is actually the H-1B modernization rule?
On December the 18th, 2024, the Department of Homeland Security announced its new H-1B modernization rule, which went into effect today, January 17th, 2025. The DHS's freshly minted rule aims to bring the H-1B program, as USCIS says, into the modern era. The stated objectives that USCIS claim are to enhance efficiency, incorporate new benefits and flexibility, and bolster integrity measures within the program. They claim that these changes are designed to not only streamline processes, but also to ensure the program remains robust in an ever evolving global landscape.
All right. So, Karen, now I would like you to know about like what's the current scenario, or because now I would also like you to make our viewers understand about the current system of H-1B that most of the people are aware of, and what can be the changes that we are going to expect in this new rule.
Well, first of all, under the new rule, there is a new form I-129, which is the application form for an H-1B, among other types of visas. There is a new form. It went into effect today, January 17th, 2025. There is no grace period. If you use any other form, it will be rejected. So that went into effect today. The most important or key change is that USCIS, or Department of Homeland Security, has revised the definition of specialty occupation, which now goes into effect today, January 17, 2025. Under this change, a specialty occupation necessitates at least a bachelor's degree in a directly related specific specialty or its equivalent. USCIS specifically states that if a petitioner requires attainment of a general degree without further specialization for entry into an occupation, that occupation is not eligible for an H-1B. So now what this actually means is USCIS is going to look not only at the degree title, but at the actual course of study. And there should be, and I quote, a directly related logical connection between the required degree or its equivalent and the duties that the employee is going to perform. So, for example, if you have a bachelor's in economics, but you're being hired as a software developer, that's no longer going to fly. They're no longer going to accept that. They want to see that you at least have courses related to computer science in your degree if you are going to be a software developer. So the degree now needs to be directly related to the job offered. That is one of the biggest changes in the modernization rule. It's designed to cater to a lot of these new AI jobs that haven't been here before, and it will accept a range of qualifying degrees. So no longer do you have to have a degree in computer science. It could be computer science, information technology, or a related field. And more importantly, the courses that you've studied should be related to the job offer. They've also changed under the H-1B Modernization Rule, nonprofit research or governmental research organizations must demonstrate research as a fundamental activity rather than their primary mission in order to be CAP exempt. So it can be just one of the activities that they're performing in order to be CAP exempt, but it must be a fundamental activity. An exciting thing is students who are on F1 visas in the US, this extends cap gap. Previously, the cap gap, which would allow you to continue working while you determine if you selected in the lottery, normally that cap gap was extended until October of the new fiscal year. Now that will go until April of the new fiscal year. So it's been expanded by December, January, February, almost 5 months. So cap gap has been extended by 5 months, which we're excited about. It ended typically on October 1. Now it will go until April 1. The one thing that I am most excited about is owner beneficiaries can now petition for themselves. So if you have your own company, you can petition for your own H-1B. This allows entrepreneurs and startup owners access to the H-1B visa, which is crucial for driving innovation, job creation, and economic growth in the US. The only thing is these H-1B visas will be valid for 18 months, not for 3 years. There's also going to be greater scrutiny by USCIS fraud division of applications that are filed. USCIS will now do site visits at the workplace. It could be at a third-party site. It could even be at the employee's place of residence if they are working from home. So people should be very aware of that. The H-1B Modernization Rule also allows USCIS to ask for documents such as contracts, client letters, and statements of work to confirm the bona fides of a job offer, and educational requirements at third-party work locations. So that's very important. USCIS has also evaluated third-party job requirements for specialty occupation classifications, and they will look at if the beneficiary will be performing work as part of the staff at a third party. They are going to look at the third party's job requirements, not the petitioner's. If they'll only be doing services at a third party, then USCIS will look at the petitioner's job requirements. So it's very important to see whether the beneficiary is going to become part of the staff of the third party or if they will only be performing services, because USCIS will look at the appropriate job requirements of whether it's the third party in the case of a staffing company, and if it will be the petitioners, if they will only be performing services at the third party. The H-1B Modernization Rule also codifies existing policy to defer to prior decisions. So if you do have an H-1B approved and you're doing a renewal, they will defer to prior decisions unless there are material errors, changes in circumstances, or new adverse information. DHS has finally put in the regulations that they will defer to earlier determinations on issues like whether a job is a specialty occupation or a worker has demonstrated that they have suitable qualifications for the position. This deference reduces risks that we'll get inconsistent decisions where one immigration officer says one thing, but on renewal an immigration officer says something different. So we are very pleased about this deference policy. The general deference policy was rescinded under the first Trump administration, but now the Biden administration, by codifying this rule, now makes it less likely to be rescinded.
Wow. I think that was in a very detailed way. And thank you so much, Karen, for letting us know for each and every rules that are going to be implementing. So I think there's a lot of new rules that are coming up on our way. And we have to be very much, aware of these new rules. But with that, Karen, you mentioned about specialty occupation. So here's a question that I would like it to know from you, that it shouldn't be a word to word degree, or it shouldn't be like if you're having a computer science course, then is it okay that the courses that are under computer science, they can opt for that also? The H-1B workers will get visa according to that, or they have to be very much particular about the exact course or the exact job that they are going to have it? I mean, how it will be.
They're definitely going to look at the courses that were taken to see that they directly relate, and that is an actual quote, are directly related to the job. So they will look at the courses. So if you have taken computer science courses and you are in a software developer's position, that should be very good.
All right, I think that's pretty much clear. Okay, and with that, Karen, I have another question in my mind, and that is about the new wage based system. So, as we are seeing that, the new wage based system is coming on our way, and applicants with higher salaries are going to give more priority as compared to those who are with lower salaries. So, how is it like how someone can check if the salary they are being offered is competitive enough to improve their chances of getting selected for an H-1B visa under the system?
Well, first of all, there is no new wage-based selection system. It's still the same system that's under flag. It has not changed as of yet, and I definitely don't think it will change, at least for this H-1B season. People can look at wages that to see if they're competitive by going to the Department of Labor flag website. They can go to flag.dol.gov. They go to the tab that says wage data, and they can see the wages for the position. I think there's going to be greater scrutiny at level 1 and level 2 wages, and probably we will get requests for evidence on those levels. At levels 3 and 4, you should be good to go. But people can check to see if they qualify based on their wages that they're getting by going to the flag website and clicking on the tab wage data.
All right. So, Karen, is it not true that there won't be any new wage-based system because most of the time, we have heard that Trump is going to implement that system.
It's
So,
going to, he may implement that system, but it's going to take time. It has to go through a regulatory process, and he certainly doesn't have time to do it before this H-1B cap season. So nothing's going to be done this year.
all right. Okay. And with that, Karen, I have another question for you, and that is, will the modernization rule implement the lottery system entirely, or will it just reduce its role in visa selection?
The modernization rule does not impact the lottery system right now. It doesn't even really address it. It's going to be the same normal lottery system that we've had in past years. I think the Trump administration may change that in future H-1B seasons, but for this current season, the lottery remains the same.
All right. And also, Karen, we have been through different news updates that's Trump is mostly he's going to eliminate the lottery system. So, do you think that it's going to happen because lottery system is one of the major process, for the H-1B visa. So, do you think it's going to happen?
That's a tough question. It's certainly not going to happen for this H-1B season. We'll definitely have the lottery, or it's just would be very, very hard to abolish the lottery before April 1. And the selection process typically takes place in mid-March. So I think that he has more important things on his agenda. But going forward in future years, they may eliminate the lottery.
All right. So, do you want to favor in the elimination of lottery system, or you like this lottery system? What's your call on that?
I don't like the lottery system. I think that we should just let market forces dictate if people are eligible. If there's no jobs available, there won't be people entering the lottery, entering the H-1B process. So if employers have jobs for immigrants, I'm all in favor of a market condition regulating this.
Wow. All right. So, Karen, here's another question, and this question is for the smaller companies. So, how will smaller companies that can't offer high wages compete in the H-1B selection process?
That's a really tough question. If they can't offer at least a level 1 wage, which is generally pretty low,
Right.
then they can't compete. So they won't be able to enter the lottery because under the lottery, you're filing a labor condition application where you warrant that you will be paying the level wage that you state. So if smaller companies can't pay those wages, then they cannot enter the H-1B selection. But a level 1 wage is pretty low. So you've got bigger problems if you can't afford to pay the level 1 wage.
Absolutely. All right. So, Karen, here's another question that is, how does this rule address the backlog of H-1B workers who are waiting for green cards, especially for Indian and Chinese nationals?
Unfortunately, this H-1B modernization rule is designed to streamline the process. It does not address at all any backlogs.
All right. And meanwhile, I think I should also look for, our viewers, those who have joined us. So, welcome, friends. And I can see Jay Prag, then Neelanjana also, and then Subhash also. So, friends, it's great that you friends have commented here, and we will definitely take these questions because after completing my questions that I have prepared, I'll definitely come back to these questions. And meanwhile, you can still post, you can still have any follow up questions or any other questions that you would like to know from today's episode. So, that would be great. And with that, here's another question, Karen, that I would like to know it from you, and that's about that how this new rule, is going to impact those employers who want to switch their job while on H-1B visa, And what are the changes to the H-1B visa transfer process? Yeah.
I think you've got to be careful now with the redesigned definition of specialty occupation and make sure that the person's courses that they took in their studying are directly related to the job. So they might have got away with before a degree in economics, not done any courses in computer science, and got the job as a software developer. We'll have to wait and see, but I think that could be problematic in a job transfer now because the specialty occupation definition has changed.
Absolutely. And that's how I think we all have to be very much careful and need to be updated with all the changes, that's happening. And that's how only you can look for it and can save your process or the problems that you might face.
Right. It
And
only went into effect today. So we'll just have to see how USCIS is going to handle the new definition of specialty occupation and H-1B renewals and H-1B transfers.
absolutely. All right. So, with this, I think this could be the follow up question because switching job and the grace period is somehow relating. So, Karen, will the grace period for finding new employment be extended, or are there other protections for workers?
At this time, there's no other protections for workers, and the grace period is still 60 days.
Oh, all right. So, can we expect some changes regarding the grace period?
I don't, I don't think so right now. You know, it's a process to make changes, but the Trump administration may make some changes to the grace period, but I don't think it will be for the benefit of beneficiaries.
Oh, all right. Okay, so I think let's see what can happen. And with that, Karen, here's another question that is, how does this rule affect spouses of H-1B visa holders, and especially those on H-4 visas in terms of employment authorization?
It doesn't change employment authorization for spouses of H-1B visa holders. A spouse of an H-1B visa holder can get employment if the H-1B beneficiary has an approved I-140 petition. Otherwise, there is no basis for an H-4 beneficiary to work in the US.
All right. And I think now, after a while, I should take some questions from our viewers. So let me take this Neelanjana question. And Neelanjana is asking that I'm currently employed as a software engineer on an H-1B visa, and my employer has filed a green card petition on my behalf. How will the 2025 H-1B modernization rule impact my existing H-1B status? And are there any potential risk or benefit to my ongoing green card applications?
Okay. I'm just reading through it.
Sure. You can answer one by one, Karen, also. You can just go firstly with the how is it going to impact her H-1B status?
Um, I don't think it's going to. The green card application isn't going to be affected by the H-1B modernization rule. It's two separate tracks. We don't know, but we will have to see if this new change to the definition of specialty occupation will impact any renewals of an H-1B. So, as long as the courses in her study are directly related to the job position, she should be fine.
Absolutely. And also, Karen, what are the potential risk or benefit to her ongoing green card application?
I don't think there's any further risks to the green card application or any benefits. It's two separate tracks. And as long as she remains in H-1B status, in lawful status, she should be fine for her green card petition.
All right. I hope Neelanjana, you got your answer. And still, if you have any follow up question or a follow up doubt, then please go ahead and post them on the comment section. We will definitely take them up.
We
And
can have we can have another discussion in a couple of months when we see how USCIS has actually implemented this rule, and we'll be able to answer a lot of these questions then. It only went into effect today, so we don't know how USCIS is going to really interpret the rule.
Absolutely. I think that's very well said. And, we can also have another discussion, another session on this particular topic regarding USCIS. So that will too be very much informative. And meanwhile, thank you so much, Karen, also for taking these questions and, explaining each things to our viewers. Next up, I would like to take off Subhash question, and he's asking that our company relies heavily on H-1B workers to fill critical skills gap in our IT department. With the introduction of the 2025 H-1B Modernization Rule, what specific changes can we expect in terms of wage requirements? So this is a pretty long question. So Karen, firstly, we are going to take the wage requirements changes.
I think as long as the wage falls within level 1 through 4 of the wage data that the Department of Labor have set, you should be fine. I think there, as I said earlier, there will be extra scrutiny of level 1 and level 2 workers to prove that it's a specialty occupation at a lower wage. But I think you will be fine as long as your job is directly related to the courses of study.
Absolutely, and that's very well said. And next up is about visa caps. So, Karen, can you please go ahead about visa caps and then documentation procedures as well?
Sorry, can you just go? Can you just scroll up to the beginning of the question?
Sure.
I don't, for right now, the H-1B modernization rule does not change visa caps. It's still 85,000 visas per year. 20,000 are reserved for people with master's degrees from the US. There is no change in that. We can't predict what's going to happen in future H-1B seasons. In terms of documentation procedures, the law is going to remain the same in regard to H-1Bs. There's no changes with that for beneficiary in submitting documents, except to make sure that, again, the courses of study in their degree are directly related to the job. They're not going to accept anymore just a general degree with arbitrary courses.
So, Karen, do you think that this general degree concept is going to benefit the US companies because now it's not about the specific qualification needed for that role or for that responsibility? So, do you think it's going to benefit the US company?
Well, they're not going to allow general degrees. Absolutely have to have degrees which have courses of study that are directly related to the job. So I think that may be tricky for some people who've got away before by just proving that they've got a bachelor's degree. Now they have to show that they have a bachelor's degree with courses directly related to the area of the job.
Absolutely. And I think that will be challenging because those who already applied courses, in the wage field, and now they have to be very much particular about which course they are going to choose for, especially for the jobs. So I
Yes.
think that's very important, and that's a very new rule, that we are going to see in this H-1B modernization. And with that, Karen, here's a follow-up question that is from Subhash. That are there any proactive steps we can take to ensure a smooth transition and minimize disruptions to our business operations?
I think just to have all your documents in place, hire your attorneys for H-1B cap season early so that they can evaluate wages to see that they are within the prevailing wages, that they can evaluate educational transcripts to make sure that the courses of study are directly related. They may have to tweak job descriptions. So I think the earlier that you get in touch with your attorney, the better.
Absolutely. And I think with that, we should also like to share contact details of our attorney, Karen Lee Pollak. And
Thank you.
Subhash, you can also connect with her. You can personally connect with her and ask any question, and she will definitely give you the best advice. And here's her detail that is, you can call her on 214 504 1227. And you can also email her on KarenLP at PollakImmigration.com. And the website is that is www.pollakimmigration.com. So I think it would be great if you could, let her know about your concern, about your problem, and she's definitely going to help you out. All
It's
right.
always
And
best to get hold of me by email. So
okay,
you can always email me, and that's always the best way to get hold of me.
absolutely. I think Subhash will definitely email you and will let you know about his problem or about his, the concern that he's going through. And with that, I would like to take up Jay Prog's question. So, welcome, Jay Prog. And the question he's asking about what are the changes being planned with the new modernization program that we need to pay attention to?
I think again, we've gone through it a few times, but make sure that your degree, the courses of study are directly related to the job that is being offered. That's going to be key since they've revised the definition of specialty occupation. If possible, I would get a level 3 wage if you can to try and avoid RFEs on level 1 or level 2 wages, and have all your documents timely to your attorneys who are doing your H-1B so they can evaluate everything in light of the new modernization rule.
Absolutely. So, Karen, do you think that this directly related concept is going to make the employers or the employees work more difficult?
Um, it may. It may. It depends on what your courses of study are. If you, as I say, have an economics degree with finance subjects and you're applying for a software developer role, I think that the H-1B modernization rule is going to prejudice you because you no longer fulfill the definition of specialty occupation.
Absolutely. And thank you so much, Karen, for letting us know about it. And I think meanwhile, we should also take other questions as well. But before that, before Ankit question, Ankit, please stay tuned and follow up this question also. We will definitely take this question after a while. And with that, here's another question that I would like it to know from you, Karen, that how do you think that the 2025 rule is going to impact the foreign students on F1 visas who hope to transition to the H1B status after graduation? Will there be any changes in how they navigate the system?
I don't think there's going to be many changes other than what I stated, that there's going to be an extension of the cap gap, which is to their advantage. So now cap gap season extends from it typically ended on October 1. Now it will go through April 1. So that's to their advantage that they've got that cap gap while they're waiting for a decision.
Absolutely. All right. So here's another question, Karen. That about now, I would like to know about the potential drawbacks uh, in this new rule. So, what are the potential drawbacks or criticism, of the 2025 H-1B modernization rule, and how it could create any unforeseen issues for foreign workers or employers?
Well, I think the criticism is there are people who are highly qualified in jobs who don't necessarily have the degrees that match those jobs. And now, with the change in the H-1B specialty occupation, that's going to be problematic, and we will have to try and explain away how their experience qualifies to make them qualified for the position, because straight away the government's going to go, they don't have a degree in this field. So we would have to explain how their prior experience and get evaluations from experts to show that their prior experience is equivalent to courses in those fields.
Absolutely. So I think now we are getting into lots of information about this new rule, and we are pretty much clear about the basic understanding what this new rule is all about, and what are the changes that we can expect. So with that, there are another set of questions also, Karen, that we got from our Facebook group. So if you allow, we could also like to take questions from there as well.
Sure.
Okay, so here's a question that we got from a viewer, that is Teja. So Teja is asking about the consular H-1B transfer, that my friend's H-1B was approved in October 2024 under the consular process, and she received her visa stamp. She was supposed to come to the US in November 2024, but didn't because her project was put on hold due to budget issues. Now she's looking for C2C jobs but hasn't found any in the current market. She found some W2 jobs, but the new employer would need to do an H1B transfer. So her first question is that does she need pay stubs for the transfer?
Yes, she will need pay stubs for the transfer because she actually is not in H-1B status. She got her visa overseas, but has not entered the United States. So she is not in H-1B status. So she would need some pay stubs.
All right. And there's another question that are there any complications with transferring from a consular H1B to another employer?
There shouldn't be any complications if she's got pay stubs and has actually worked for them. But if she hasn't worked for them in H-1B status, there's nothing to change. So she can't do a consular transfer.
All right. I hope, Teja, you got your answer. And as Karen said, I hope it will be helpful for you. And with this, we would like to go to next question of that we received from Facebook group. And that is from anonymous member. And the question is about H1B transfer and expired visa. So I used just 1 year, 10 months of H1B max out. I returned to home country last month as my employer did not bridge in amendment as client was being changed, while extension is pending approval with USCIS. Since my visa has been expired, can H1 be transferred while in India to a new employer? What's
Yes,
your
it
thought?
wouldn't be a transfer, it would be new employment. You would check the box that says new employment, but it is possible as long as they can show that they have the last three pay stubs while they were in the United States, they left the country, they will do a new employer H-1B.
All right. And there's another question that we got from a viewer. It's about hello, I'm currently on STEM OPT till June 2026 and have a master's degree from the United States. My employer applied for my H1B visa last year, but I wasn't selected. This year, is there a greater opportunity? Yeah, Karen, let's go one by one.
Okay, there's no greater opportunity. There's 20,000 H-1Bs reserved for people with master's degrees from the United States. So they would first go into the general pool, and if not selected, then they will go into the master's cap. So they would have a second bite at the apple to see if they are approved. But there's no changes in the selection process or greater or lesser opportunity.
All right. Okay, and in addition, my employer told me that he would apply for a green card on my behalf if I didn't select it this March. Do you think there will be enough time to do so?
Uh, he's from Lebanon. I'm not sure what he means by will there be enough time to do so. And a green card through employment is going to take at least 4 years for somebody from Lebanon. So if he means will he get his green card um, before his STEM runs out in 2026? The answer to that is no, he won't. It's going to take 4 years. And applying for a green card doesn't allow you to stay in the country. So he'll need to apply this year and next year, if not selected in the H-1B cap or change to a student visa to stay here while he waits for his green card, which will take 4 years.
Right. So I'm hoping that this answer, this advice is going to be very helpful for our viewer. And with this, I think we should move ahead with our next question that we got from our Facebook group participant. And Okay, this I think we took. So let's take up some other one. I think this is also the one that we took, Teja. Yeah, this is the one that we should take. Okay, so Karen, is there any difference after I-140 approval between EB2 normal perm and NIW perm? Any possibilities of getting GC faster in NIW process?
No, no, the EB2 process for national interest waivers and general EB2s is determined by the visa bulletin, and it's the same time.
Okay. And the other question is that is day one perm is a myth? An employer is promising me to file the perm within 1 month of joining with them, saying they already have the PWD. Is it a doable thing or what?
Well, it depends how far they are in the process. If they've got a prevailing wage, which typically takes 6 to 7 months, and they've already done advertising for the job, and that person meets the requirements, then yeah, they could possibly file perm on day one if they've done all those steps and they've got them and the employee qualifies for the job. They would have to have advertising that's up to date, so it's not more than 60 days old. I'm sorry, not more than 6 months old, and it's possible. Yeah, it's possible. Unlikely, but possible.
All right. Okay, and Control, if you could show us some other questions also, if there's another question regarding the H1B thing. Okay, so here's another question, Karen, that I would like to take up. That is, my company filed the H1B petition extension on 18th November 2024 in premium, but still online status is showing they are actively reviewing the Form I-129 and nothing is outstanding. I asked my attorney why it is getting delayed in premium. Usually it takes 15 to 20 days for approval, and he said he will be refiling the upgrade to push my case. Just wanted to check if anyone else is facing the same issue, and Karen, please go ahead and share the advice.
Well, I don't know what the answer to this is. It normally takes 15 business days, and if you write to the if you email premium processing, they're pretty good at responding to you. So something doesn't sound right here. I don't know why he would upgrade again and pay another $2,805. Perhaps they never filed in premium processing in the first place.
Questions that we got from. Hello, Karen, can you hear me?
Now I can, yes.
Okay. Okay. So yeah, I think so. These were the questions, that we got from our Facebook participants, as well as they mostly put up these questions regarding the H-1B and the different visa categories. So we took this question, and now I think I should take Ankit's question. So Ankit is asking that I am a Canadian citizen working in the US on an H-1B visa, and I'm planning to get married to a US citizen. How will the 2025 H-1B Modernization Rule impact my ability to switch to a different visa category, such as a K3 or CR1 visa? And what are the implications for my immigration status and future US citizenship eligibility? So
Well,
that's a lot.
congratulations on your wedding. Congratulations. The H-1B modernization rule will have absolutely no impact on you filing for a green card through marriage to a US citizen. In fact, that's a really easy process, and it has very few problems associated with it. It's a very easy process. It's a lot of documents involved, but if the documents are completed properly with the supporting evidence, you should be fine. But it has nothing to do with the H-1B modernization rule, and there'll be absolutely no impact.
All right. So I think, Ankit, you got your answer. And still, in case if you would like to know more about it, or if you have any follow-up question, then please go ahead and share them on the comment section. We will definitely take them up. And with that, I think we already took, most of the comments, most of the Facebook questions also. And I think Jproc has asked about, is this started? So I think it's the date is only this 17th January, right, Karen, that it's going to implement.
It went into effect today, January 17th.
Right, absolutely. So I think Jay Prag's question also we took, then Subhash also, Neil and Jana. So there were different viewers who joined us and who asked these questions. So it was really good to know about it. And with that, Karen, here's another question that I would like to know it from you. And this is a different question, like it's going to be a little political question. So I would like to know it from you that politically the H-1B visa has often been a very topic of debate, between different parties. So, how do you think that the 2025 H-1B modernization rule will be received by Biden administration, Congress, or other stakeholders?
Do you mean the Trump administration? The Biden administration is almost over. So
Oh, right.
I
Sorry,
think,
sorry.
um, well, there's been a lot of controversy over this. Um, so far, there's been a little Twitter war or X war between Elon Musk and others over the H-1B. And Elon Musk is very in favor of the H-1B petition. He was on an H-1B.
Yeah.
Trump seems to have Elon Musk's ear. So I think that Trump will favor the H-1B. Now, there are people in his party who are very anti-immigrant and anti the H-1B, saying the H-1B suppresses salaries, it makes people indentured slaves, all sorts of things out there on that. It's taking jobs away from Americans. And so there are people who are against it. But I think as long as Elon Musk is in the position that he's influencing President Trump, we are good to go with the H-1B.
Absolutely. And I think we should hope for that also, because nowadays we are seeing more Trump and Elon Musk. They are getting close together and they are having a very friendly relationship, because also
Until
the
until
business.
they fall out, which will happen. There will be a fallout. We just don't know when.
Right, right, right. Absolutely. But also, Karen, I mean, what do you think? Because, most of the people, they are saying that H-1B workers, they are getting less payment as compared to the actual US people, US born people. But still, there's a different criticism that's going on, because for the same job, the US people are getting paid highly as compared to the H-1B workers. So, how is it like why people are into this discussion that H-1B workers should be banned or it shouldn't be allowed? I mean, what can be the reason behind it?
Well, it's, I mean, I don't know, but I think it's fear. People are scared and they're worried about their jobs being taken. They're worried about layoffs. Sometimes you hear about these big companies laying off hundreds of thousands of people, but they're still hiring in H-1B. And people question, and it's a good question, why are you laying off people but still hiring H-1B workers? If there's a layoff, it means you don't have enough jobs. So, there is that argument by proponents who are anti-immigration. Um, but generally, wages cannot be paid, American workers cannot be paid more than foreign born workers. It would be wage discrimination. And that's why the Department of Labor has prevailing wages that you have to pay so that it can regulate the wages that are paid.
Right, right. And there are, so many criticism also that most of the time H-1B workers go through. But still, most of the time it's like anti-immigration or anti-H-1B workers. So I think automatically, H-1B workers, they are benefiting the US nation a lot and contributing a lot in US economy. But out of that also, most of the time it happens that they have to face lots of discrimination, lots of criticism also. But I
Yeah.
think, Karen, it's very evident, that H-1B workers are really contributing a lot in US economy. And that's pretty
Absolutely.
much well known by Elon Musk and by Trump also this time. So I would just like to know it from you that there's a kind of conflict going in Trump's administration, Trump's team itself, because it's like Mega versus Elon Musk, and
Right.
there's a conflict, right? So it's very interesting to know about it, because now what Trump used to say in his first term, that he's going to be very much strict about the H-1B workers, and now we are going to see his statements that he's favoring H-1B workers. So, what's your call on that? I mean, do you think that Trump is going to favor Elon or his mega team members?
I think right now it's clear that he's favoring Elon Musk, and as long as um, Elon has Trump's ear, then we're good with the H-1B program. But President Trump is very erratic. We just, can't tell.
Absolutely, we can't say. And he's also very unpredictable,
Right.
because there's so much, that he says, and that too without even a second thought. So, that's what we can expect in this year. And I think we have already talked a lot about today's topic, and with that, Karen, here would be my last question from you for today's session. That what final advice would you like to give to foreign workers and employees who are navigating the 2025 H-1B modernization rule?
I think that they just need to have their documents in a row. If they don't have courses of study that are directly related to the job offer, they need to get expert opinions that their work experience counts to be like courses that they've studied. And it's not just simply getting registered in the lottery, it's a matter of getting all your documents to your attorneys as soon as possible so they can do an evaluation.
All right, I think that was pretty good. And Karen, here we have another comment that we received from AJ. So AJ is asking about like national security, sovereignty, and economic security must be considered when crafting employment and immigration policy that strains Americans' resources to accommodate these foreign nationals. What would you like to add on that?
I'm not sure what they're asking.
Uh,
It's not
I
clear
think
to me.
he's. Mhm.
I think they're just making a statement that,
Yeah,
national security must be taken into account when issuing H-1B visas. Well, national security is taken into account. Um, you've got to provide a lot of documents. You've got to provide past visas. Often you've got to go to the consulate for an interview. They go through a whole lot of questions. Have you been convicted of a crime? Have you ever overstayed your visas? So I think those things are being taken into account.
absolutely. I think, yeah, AJ was about to have a discussion. So he's not asking any question. He's just putting up his point. So I think that's what, yeah, he wanted to add. But anyways, I think that's pretty much discussed. And thank you so much, Karen, for, I mean, sharing these insightful answers with us, and also letting us to know about so much, not only just the H-1B modernization rule, but also about what we can expect in Trump's administration, and how everything can go. So there were lots of important points that we discussed in today's session, and
Yes.
I'm sure that you also liked it. So, Karen, would you like to give any last message to our viewers about this topic, or anything that you would like to share with our viewers?
Well, thank you again for having me on the show. It's an honor and a privilege to be here. And I just want to wish all potential H-1B applicants good luck in the lottery. Get your documents together, get any expert opinions together sooner rather than later, because that's going to impact your registration.
Absolutely. And to have an expert opinion, I would like to recommend attorney Karen Lee Pollak contact details. You can go ahead, friends, and give her a call. That is 214-504-1227. Or it would be best if you could email her on the email ID that is KarenLP at pollakimmigration.com. With the website, also you can go and visit her website. That is www.pollakimmigration.com. And with that, thank you so much, Karen, for
Thank
joining us
you.
today. It was our pleasure, and we are really happy that you joined us, and we will definitely have more sessions together. I hope we will have, right?
Wonderful. I enjoyed
Okay.
it. Thank you very much.
Thank you so much, Karen. And thank you
Take
so much, everyone, also for joining us and asking these questions and commenting here. It really gives a lots of motivation that you people are watching us right now. So that's all. Thank you so much, everyone, and stay
care.
informed, stay connected, and also don't forget to like, share, and subscribe to our channel. We come up with lots of information and lots of webinars with different attorneys, and we'll make sure to let you know about each and every details, each and every updates that's happening in the world of immigration. So thank you
Thank
so much
you.
for joining, everyone, and thank you,
Share
Karen, too. Yeah.
If you can share this with me, that would be appreciated.
I would definitely do that. And we will be happy to share that as well. So, anyways, I think now it's almost time. So, thank you so much, Karen. It was lovely, wonderful having you again. And thank you so much to our viewers also. Good luck and take care, everyone. Bye bye.
Thank you. Bye bye.
Bye bye.